Hello guys, and welcome to another episode of my lecture. In my last class, I discussed what a document is under section 258 sub 1 of the Evidence Act. In this lecture, I will discuss what primary and secondary evidence is. Now, when you are talking about primary evidence is the original document. Do you understand? Where there is a contract between two parties, the one that they signed with their biro, both of them appended their signature, that is the primary evidence. Now, a facsimile of that particular document, that is a photocopy of it, would then be the secondary evidence. Do you understand that? I need you to, have that at the back of your mind. Now, there used to be a rule under the common law. If you look at the case of GARTON versus Hunter, Lord Denning abolished that rule. But that rule is known as the best evidence rule. And that rule states that once you are able to admit the primary evidence, without doubt, that particular issue which the primary evidence seeks to prove is proven. Do you understand? Without any, doubt. Whatever you admitted that primary evidence for, whatever that primary evidence seeks to prove is proven. That's under the common law. But Lord Denning, in the case of GARTON versus Hunter, seemed to have, watered down the effectiveness of that principle. But theoretically, practically, it is still being practiced in court. Because, when the original document of something has been tendered before the court is more inclined to make that a conclusive proof of the fact which you intend to prove. Do you understand? As opposed to when you are adducing a facsimile or you are adducing a photocopy of a particular document, which to a particular extent there may be certain doubts. But that principle, like I said, has been watered down by Lord Denning. Now, if you look at the case of Lucas versus Esher, where the court was trying to tell us what exactly secondary evidence is, it stated that primary evidence is evidence which the law requires to be given first. Secondary evidence is evidence which may be given in the absence of that better evidence when a proper examination of the absence has been given. So you see that. Now let me now take you back to the mock trial I was talking about. So I wanted to tender the printouts of someone's biodata into evidence. That was the printout. He had signed on it and then he wanted to tender it into evidence. The other party then objected and said that that particular evidence is not a primary evidence, it is a secondary evidence, because you can't say that that is the evidence which the school authorized. Do you understand? Like the initial document that has been tendered, that since it is being printed from the online, then it means that that document is secondary. Do you understand that? Now, the thing that he was trying to do, like I said earlier, when you want to tender a secondary evidence, and let us look at what Lord Esher said in the case of Lucas and Williams, where there has been a proper examination as to the absence of the primary evidence, which means that the witness through whom you seek to tender that evidence must have stated in evidence why the first one is not available. It is when we cannot find the first one, that is the primary evidence, that you can then tender the secondary evidence. When you just seek to tender secondary evidence without laying proper foundation as to the absence of the primary evidence, the court can reject that particular document. Do you understand that? So you need to understand how evidence works. You are about to tender a secondary evidence. You need to lay proper foundation. Section 87 gives you the ability to tender secondary evidence, but such must be tendered with proper foundation. Section 86 tells you that you should tender primary evidence, but in the absence of that, you can tender secondary evidence. Do you understand that? Now, for the conclusion, what the judge ruled on that objection, the judge overruled it because the judge held that that was the primary evidence. What other evidence could have been better than that? Do you understand? What other evidence could have been better than the biodata which you printed from online? However, there was another objection which you ought to have raised. When you seek to tender an electronically generated evidence, you need to prove it in accordance with section 84. But he did not object. If he had objected, I had not followed the procedure of section 84, where you have to, bring the certification of the computer and all that. I had not done that. So at that point, the objection shouldn't have been on whether or not it was the primary or secondary evidence. The objection should have been that the provision of section 84 as regards tendering electronically generated evidence has not been followed, and therefore the court should strike the evidence out. But he did not object. You see why you need to pay apt attention to this particular lecture, especially when it comes to understanding the nitty-gritty of evidence. So yes, with that, I've been able to explain to you the difference between primary evidence, secondary evidence, not just that, documentary evidence, oral evidence, not just that, fact and fact in issue. In my next class, we will be talking about other types of evidence. See you in my next class.